bill. We took this bill by because Delegate Levine had some witnesses from Abington who had testified very passionately in the civil sub. Yes, from Abington, not Arlington. Who were unable to be at the last meeting, and out of respect for them, we wanted them to be here. So Tyler and his mom are here today. Thank you for being here. House Bill 2128 reported out with a sort of strange 4-3 vote with some non-votes, and the bill is before us. And I voted against it, so I won't make the motion of the subcommittee, but that was the subcommittee's recommendation, 4-3.
Mr. Chairman and members of the committee, HB 128, for those who are in the civil sub, they know all about it, but I know half of you or so, it's new to you. Basically, under current law, courts are not required to consider abuse that occurs outside the family. The courts are required to consider in a long list of factors sexual abuse and family abuse. And family abuse is defined as abuse that occurs within the family or within cohabitating people and so forth. But there are a number of cases where courts have said that because of this law, as it is written, they haven't considered abuse that occurs outside the family. This is the law to allow courts to consider it. It's just a factor. They can consider it and decide it's not important, but it's very important to allow courts to consider it. The family lawyers that I contacted were all in trial because they're very busy, but I passed to each of you 3 letters, one from Abingdon, one from Henrico, and one from Chesterfield, and each...
Hey, Mr. Chairman, just so that everyone's not confused, and I asked Delegate Levine to pause. We never did adopt a substitute to this one, which is important because it's a significant difference, and I want everyone to have the right bill in front of them. So can I move the substitute, which is in front of you? And what that substitute does is strikes the definition of other abuse. It just has 2 words, or other abuse 3 words, something like that. All right, sorry. Go ahead.
Thank you, Mr. Chairman. I thought we had adopted it, but either way, thank you for adopting it now. I am talking about the amendment in nature substitute, not the original. So thank you for that clarification.
The substitute should be in your packet. Okay, Delegate Levine.
The only change to the bill is in line 9. And you can see it on page 2. And all it does is add the words "or other abuse" to the factors a court must consider in the best interests of the child. And what you'll see from these 3 family attorneys, and I know that Delegate Campbell also is a family attorney, and he's co-patroning the bill, and I appreciate that. Also want to thank Delegate Kilgore and Delegate Krizek for co-patroning the bill. But Delegate Campbell and these other 3 lawyers will tell you that courts don't always consider abuse that occurs outside the family. They always use that 10 catch-all phrase to consider it, and they give you lots and lots of examples here. One was a man who beat up a pregnant woman that wasn't considered. One is, the first one, she gives lots of examples. The other point that the attorney, Ms. Lauren Caudle points out is that there's an interplay between the 9th factor and the 6th factor. So the 6th factor says, in normal cases, we want parents to get along. Even if they don't get along with each other, we want them to foster good relationships with children, and that's normally a good thing. But when one of the parents is abusive, physically abusive, sexually abusive, there's an exception in 9 that says if court finds this history of abuse, the court may disregard the factors in subdivision 6. So the court doesn't have to try to foster a relationship with an abusive parent. Unfortunately, without other abuse being included, the court is actually being directed by the General Assembly that they have to foster a relationship, even if there's abuse outside the family. And lastly, included in your packet is the statement of 14-year-old Tyler. I would like, if with the Chairman's Commission, to give him a chance to say what happened to him.
Right, this was on a contested document. I guess we can have some public comment. You said Tyler's here. After this bill, I need to get Delegate Marshall's bill up because he's got a witness that has to leave. Yes, sir. Go ahead.
Hi, my name is Tyler Strong. I'm here today to talk about events in my life and no child or adult should have to go through. I experienced mental and physical abuse from my father for many years. For example, some things he would do to me: slap me in the face, hit me in the side of the head, punch me in the stomach, pull my hair, push me, pinch me. He'd also say things that would make me feel like I was worthless, tell me I was stupid, other names that included cuss words. And he said he was embarrassed that I was his son. When he was really mad, he'd slap me to the ground and pull me by my hair multiple times. On a few occasions, he even locked me in a dark room for many hours for telling my mom the things he was doing to me. The worst times were when he would slap me and hit me in the head and push me to the ground, or I'd fall to the ground and he'd drag me up by my hair on the top of my head. It happened on a couple occasions, and those times I was crying and begging him to stop. He kept hitting me. In those moments, it made me worry that he'd be angry enough to not stop hitting me, hurt me really bad, or even kill me. I did everything I could to try not to mess up, to keep his secrets, to not tell what he was doing to me, and do anything to keep him from getting angry and losing his temper. On a couple occasions, I tried getting help and telling people, but I still had to go with him, and I did whatever he said to keep him from getting angry at me. I lied to people. I did not tell what was going on because he would always find out what I told. I ended up getting hit or something worse. He made me feel like I deserved these things, and I couldn't do anything right. I felt like nobody would help me. It seemed like his anger was unpredictable. Each time of abuse, it seemed like it was worse each time. In May 2014, I did not reach my father's expectations in a baseball game, and this resulted in him saying to me, "I'm going to beat your ass when we get home." And from past experience, I knew what that meant. I was scared of what was going to happen because of what he has done before. He told me to stay in the dugout while he was umpiring the following game. I left the dugout to find my mom, even though my dad was yelling at me to get back in the dugout. I found my mom. I was crying and upset and told her I needed to leave with her. She tried to reassure me that it would be okay until she saw something was wrong with her. I couldn't tell my mom what was wrong in the field because I was afraid my dad would hear and have heard what I told my mom. I kept most of the abuse away from my mom and hadn't really told anyone because of what happened. When my dad found out, I was scared to tell. My mom took me and we got in the car, and leaving, I began breaking down and telling my mom some things that my father did to me. She took me to the magistrate office that night. He took me in his office and he began asking me why I was here, and I only told him some of the things because I was still afraid to tell everything that happened because I didn't know if I was going to be protected or not. Since that night, I've been protected from my dad. I had to go through court, testify, 2 years of counseling, and live through the fear that I might have to go back with him. It took 2 years for court to be over, and it did not finalize until July 2016. I have not had to be in my abuser's care since May 2014. One question, I wondered why would no one help me? And why would no one listen to the things he was doing to other people and cared about the other abuse? Why didn't anyone care when they knew my dad had beat up his girlfriend, hurt her son, breaking things, threatening people, punching holes in the wall? I told my mom. She told attorneys and GALs, and they told her I had to go, not to violate the order. And my dad would tell me that he would get my mom in trouble if I told social services the things he was doing to me. I gave completely up and just took the abuse. No one cared or listened before. And then the other abuse started. When I saw him do to others, he did to me, and it got worse and increasingly. I knew if he was mad at me or anybody, I was going to get it, and I had to go through it to take it, because people knew he was hurting all these other people, but nobody cared or helped me. It started in 2012 at my dad's work. I said something I wasn't supposed to say, according to my dad. And he slapped me down to the ground in the side of the head and pulled me back up by my hair over and over. I never told my mom until 2 years later because I lived in fear and nobody ever did anything about the other abuse. The other abuse had become my abuse. That I will never forget through the years I was abused and living with an abusive person. But I'll strive every day to overcome the abuse and help someone avoid what I had to go through. Please, today, use my abuse experience to spare other children from being abused. Other abuse to the girlfriend, to the girlfriend's kids, and to other women eventually became my abuse. Please listen, please help. Thank you.
Well, sir, you're a good man to take something bad that happened to you and try to make sure that it doesn't happen to other people, so you should be really proud of yourself.
Thank
you for coming. All right, anybody else in the audience?
I just want to say that Tyler's mother, Misty, is here if you want to ask her any questions.
Okay. Come on up.
Good afternoon. I'm Kim Ramsey. I'm here on behalf of the Virginia Family Law Coalition. And although no one would say that the things that happened to this young man should have happened to him, there's no question about that, we do oppose this bill because of the broad language in the bill, the other abuse. And the fact that when there is, in this particular case that you've heard about, there was family abuse. What we are concerned about are the words other abuse and how broad that is, and the way that that could be construed. Giving an example, if there was a young man maybe just out of college who is in a barroom brawl when he's 22 years old, and then 18 years later he's a 40-year-old man, he's been married, he has a few young children, he's been a good husband, a good father. Let's say wife has an affair. Wife leaves husband and says, you know, I want my new boyfriend to be the dad for these children. And so she keeps the children away from dad and then wants to come into court and bring up the fact that there was abuse of a party years before. She can do that, and then the court would have the ability to disregard paragraph 6 of that code, which would mean that she didn't have to reasonably foster the relationship between dad and the children. And that's what we don't want to happen, because that's a situation that's remote. It is not relevant in this case, but it doesn't need to be if this is put into the code section. The way it's written now, any sort of relevant abuse could still be brought into the court through section 10, which is the catch-all. If there was abuse going on to a child, the child's mental health is already an issue in the code, and as is the parent's mental health. So all of these are ways to get abusive nature into the court and have the court consider it, but only if it's relevant. And the problem is if these words of abuse are put in, it takes that relevancy out of it, and then the other parent can use that as a sword rather than a shield by not adhering to section 6 and trying to foster that relationship.
Okay, thank you very much. Delegate Levine.
And Mr. Chairman, just wanted to sort of give a little background of where this bill's come from, what we've heard, a little bit of the pros and cons, just bring people up to speed. And Tyler, Tyler's a remarkable young man who, when you consider what his experiences were and the kid you saw before you today, just think who that kid's going to be in 5 or 10 years. And that's really, I think, a credit to him and to his mom. And we got to meet Tyler's story through his mom last year on a similar bill. And there's no question about sort of the horrific nature of what he's gone through. What we've been evaluating on the civil subcommittee is whether or not this was a hole in the law or a judge who was misapplying the tools that had been given to that particular judge. And I think those of us who voted against this bill both last year and this year did so because of that issue. So let me explain it just a little bit. And in addition to the Family Law Coalition, who opposes this bill, the Virginia Poverty Law Center also opposes this bill because of the potential abuses in the system built into that other abuse language. And the testimony we heard, beyond what you've heard here now, is that the other factors set forth in section 10 and the physical, mental condition of each parent set forth in section 2 are routinely and essentially universally applied by judges in these types of cases. And frankly, the practitioners, and you do have some letters today that Delegate Levine has provided that maybe have some practitioners with a different opinion, but the practitioners we heard from, frankly, were just shocked that any judge put Tyler and his family and the other folks connected to the family through the systematic abuse that they went through by simply misapplying the statute. And so, but what we've sort of created for Delegate Levine and for the supporters of this bill is a little bit of a catch-22, because his original bill had a very specific definition of other abuse, which caused its own set of problems. So his substitute removes that definition, and removing the definition creates its own set of problems because of the vagueness of that language. And so we've sort of found ourselves for 2 years now trying to find a way to do it right, and every attempt we make, the practitioner associations, the Poverty Law Center still oppose it. There is one disagreement that I think is a bipartisan disagreement with the patron of this bill as to the application of section 6. The reason that section 9 is relevant is it allows you to disregard the factors in section 6. It does not require you to place a child with an abusive parent. It does not require you to grant access. It simply allows you to disregard the factors set forth in 6, the factors being the propensity to actively support the child's contact and relationship. And again, the patron disagrees with that interpretation, but I think the panel was rather universal that not having this in 9, applying 10 or 2, does not require granting access or visitation or anything else. It just eliminates those propensity factors. So again, as we oftentimes are forced to do on this committee, we're presented with horrible anecdotes, and the question then becomes, is this horrible set of facts a judge problem, a system problem, or a code problem? You can see from the vote that there's disagreement amongst the civil subcommittee. So those of us who voted no do so because we think this was an application problem, and we're creating more problems based on what we're hearing from the practitioners, but totally understand those who vote yes, including the members of the subcommittee who are working with Delegate Levine to craft this legislation. And so the bill has had a full hearing, 2 years now, versions of this bill. You do have additional information by supplement that Delegate Levine has handed to you. For the reasons that the Poverty Law Center enunciated to us and the family law practitioners enunciated to us, I'm going to vote no again because I think we're creating potentially more problems by passing this, but totally understand and respect why Tyler and his mom and Delegate Levine have continued to fight this fight, and I expect will continue to fight this fight if this bill doesn't go forward.
Delegate Bell.
Question probably for Delegate Levine or staff. So, is other abuse defined anywhere somehow?
Mr. Chairman, I'd say it is not. The bill as introduced had a lines 40 through 45 that said for purposes of this section, quote, other abuse means, and then had a long definition. The problem that folks had with that is you may be excluding something that should be included. You may, and so the idea was maybe they could solve the problems by striking that definition. By what we now find ourselves is by not having a definition, the word abuse is totally up to the interpretation of the court, which we trust them oftentimes to do that, but that could be drug abuse and animal abuse and workplace abuse and any number of things which may or may not be relevant factors, which is why people, the opponents, believe that the catch-all in 10 already provides that broadness to capture what they need.
Delegate Bell.
I'm going to say some things to staff so that a non-practitioner just sees if I got it right. Is that simpler than asking a series of questions? Okay, so if abuse could cover the guy who likes to go to fights once a month at the bar, what other guys? Just that's his thing. And Section 9 provides a special carve-out for Section 6, meaning it's not just another factor, but it actually is more significant than other factors. Is that the lady provided a fact pattern along those lines, but is she right? Is it consistent? Somebody that's never hurt a child, never would hit a child, but doesn't mind rumbling on Friday, would then have not just that it's a factor, but a special factor that would actually veto the Section 6 factors that seem also important.
Mr. Chairman, I believe that if it was just abuse and not defined or narrowed in any way, then yes, it would. The court could say, I'm going to disregard the fact that the mother or father kept the child from the other parent under, defining that there's abuse under Section 9.
Just share one more, just about something I know much about. Why, we have a Section 10, I guess that there's a question why we have any of this stuff. What are judges doing? I mean, 6 has we have a special, this veto is that, aside from that, the other factors are just things they have to talk about. Somebody that does this work can maybe tell me
Mr. Chairman?
why the 10 isn't just a perfect catch-all for everything, just says judge taking into account best interests.
Yeah.
Delegate Levine, answering question.
Yeah, so I think this is, you can see how these statutes grow over time, where people say judges can consider factors, and then the General Assembly says, well, there's some we really want you to consider. I think the reason 6 has a special carve-out is 6 essentially allows you to attempt to make good for abusing somebody. So you financially support them, you spend time with them, and so what they're saying is if you are abusing somebody, you shouldn't be able to buy your way out of that abuse, is why 6 is a special factor that gets carved out. The issue you have, though, is because abuse can be defined in lots of ways. For example, is alcohol abuse abuse? If alcohol abuse is abuse, which would otherwise fit in Section 2 probably, which goes to the mental condition, are we now allowing you to write out 6 by using what it's supposed to be in 2, but it's now dropped into 9. Again, I think every single person agrees that if the code has a hole that caused Tyler and his family to experience what they experienced, it should be closed. And on the flip side, if the code is appropriate and a judge had a hole that allowed that to happen, then we wouldn't advance the bill. And again, I thought the greater weight of the practitioners was that we shouldn't fix the code, we should make sure our judges are educated, but others disagreed and it was a close vote.
All right, so we're gonna be here until 11 o'clock. If we don't keep the wheels moving.
May I just briefly
You
say
want to say
something?
something?
Actually, yeah, Ms. Russell.
I'll give you, if you can.
I would like a chance to briefly respond.
Okay. Real quick, please.
Actually, I just wanted to say, I recognize some of the faces when we did House Bill 588 with Mr. Campbell last year with protective orders, which was common sense, and kind of the response was similar to, we should already know, they should know that they should keep a child or keep the abuser away from the victim. But it was kind of the clarification was needed, the wording. And I feel like in this case, in the real world, in the system, that other abuse is not considered. And there's, unless it is directly done to the child, and in approaching attorneys to pursue something to protect Tyler, I was told until the abuse was done to the child, there was nothing that could be done. There are several cases that I've heard of similar in the state of Virginia. For several years, since 2009, we tried to protect him from the abuse that was going on to the girlfriend, to other girlfriends, to the children, and I was told that I would be considered alienating him from his dad, and until repetitively I consulted different attorneys throughout Southwest Virginia, even in Roanoke, and was told the same thing, until the abuse was done to the child, but there was nothing I could do. And I think the attorneys are actually the gatekeepers to this. And they're not going to pursue a case until they know they have a case that they could possibly win. And that other abuse will just open the door to allow it to be considered for a child, or allow the history of excessive abuse to be considered to possibly prevent a child from being abused. And even though I'm here as a mom, I'm also an MSW, and I'm going to tell you that it is common sense that if someone has a history of abuse, they are probably most likely going to abuse someone else when they're in a situation or a tense situation to do so. So I think it's just only common sense to consider the abuse, because I know in my son's case, and being an educated person, I tried every avenue to protect him from this situation. And I imagine those who are not as educated, who just accept what attorney tells them, that's no, I'm sorry. The message we're sending to kids is to take the abuse, and it's not okay. And it's 2 words that could possibly prevent what happened to him. And I think the judges in the courtrooms have common sense enough to filter out if a bar fight 20 years ago is going to affect a child today.
Okay, thank you very much. I mean, you get the last word.
I would say this, all we're doing is allowing factors to be considered by the court. That's all we're doing. We're saying, court, consider this. And if the whole idea is that courts have discretion and we trust courts to make the right decision, let them consider, as the 3 attorneys, and I really ask you to read their letters. One of them said that a guy beat up his pregnant girlfriend, and the court said, you can't consider that. You can only consider whether he beat up you. Yeah, he beat up his pregnant girlfriend. That's not family abuse. 2 other lawyers, again, it's not just one judge. It happened in Enrico, it happened in Chesterfield, it happened in Abingdon. Read those letters, and these practitioners are saying, we want to bring in this other abuse. I would be fine if this would be the difference in the committee to say, or other similar abuse to non-family members. I actually asked the family lawyers to talk with me about language. They refused to discuss it with me. I will tell you the family lawyer that talked in subcommittee, he said there had to be a nexus. He said, came up and testified and said, if a man has harmed one child, that doesn't mean he's going to harm another child. And that was his reason for opposing the bill. I strongly disagree. I think any man that would harm a child is at least that should be considered for another child. So if that amendment would help, I'd be happy to do that. No one cares about the bar fight. I think courts, frankly, would exclude that. Let's let the courts decide and bring it in.
Okay, thank you very much. Does anybody, committee members, have any questions or comments? Is there a motion on the bill?
Mr. Chair, can I make a comment into the bill?
We got a push button. Okay, I'm sorry. I'm hitting the wrong buttons.
I want to just say, last year I didn't support this. This year I am. I think the key for me is
it's that it's a history of abuse, history of other abuse. I think that's the key. It's not a one-off, it's not, and I think that really makes a difference. Thank you very much. I would like, can I make a motion?
Well, hold on a second, I didn't hear you yet.
I was about to make my motion.
Okay, what you
I
making?
moved to report the bill.
For a second. Moving to second report, all those who want to vote this bill indicate you vote on electronic voting